appellate attorney and trial attorney Matthew Barhoma. Matthew, just let me summarize real quick. What the state is saying is essentially they want to bring in evidence of Anthony Huber's peacefulness, because they're claiming that just by virtue of a self-defense claim by the defense is entering evidence that he was the first aggressor. And so they're allowed to bring in evidence of his peacefulness. But the defense is saying, we're not bringing in evidence. It's just evident on the video. The video itself shows him, and the jury can decide, is he the first aggressor or not? I want to get your thoughts on it. Interesting issue.
Absolutely. They're trying to get away with evidence that otherwise would possibly be character evidence, and they wouldn't be allowed to introduce it, all by virtue because of the way that the defense is handling their case. Now, that's not how it goes. The defense has to blatantly open the door for the prosecution to be able to walk through it and introduce this kind of evidence. So that's why there's this quarrel, and I think that this judge is possibly getting it right.
And let me ask you this quickly. We only have a couple of seconds. So just the fact that they're going to give that video that shows him being the aggressor, that's not enough, correct?
No, they have to use it as such. So they have to rely on it as such, or they have to paint it out to the jury as such. Doing that, now that's a blatant move. It's called opening the door. And otherwise, the evidentiary code would allow the prosecution to bring in this kind of evidence that they're trying to introduce.
All right.